Welcome to Legal Talk, the talk show brought to you by the law firm of O'Donnell, Weiss & Mattei. We have offices at 41 High Street in Pottstown and 347 Bridge Street in Phoenixville. We can be reached at 610-323-2800 or online at www.owmlaw.com. My name is Joseph Koury. I am part of our Business Law Practice Group, and today with me are my colleagues from the Business Law Practice Group, Gary Stein and Jim Kovaleski.
Hi, Joe.
Thanks for joining me, guys.
Absolutely.
We'll be talking today about pros and cons of forming a limited liability entity for conducting your business. Many of you will be familiar with conducting business without an entity in place, a so-called sole proprietorship. And I know in my experience, I've dealt with many sole proprietorships conducting business, and I'm certain the two of you have as well.
Absolutely.
So probably the headline, if you will, with regard to sole proprietorships is that they do not afford any asset protection. Gary, perhaps with that softball introduction, you could tell us a little bit about what that means.
Or liability protection. A sole proprietorship basically is an individual doing business as him or herself or under a trade name. A fictitious name can be registered in Pennsylvania for a small fee with the Department of State in Harrisburg. If you do that, it gives you what we call non-exclusive rights to use that trade name in the Commonwealth of Pennsylvania. But the key for that is that you don't have any protection from debts incurred in the operation of that business, or what we call liability protection. If you owe vendors and you get into trouble in the operation of your business, the vendors can sue you personally. That's a big risk, and it can be easily dealt with by filing documents that afford you with some limited liability protection. Two most common situations are forming a corporation, or more recently, forming what is called a limited liability company.
And we'll talk a little bit more about those types of entities in a few minutes. Jim, given what you've just heard from Gary about really no protection afforded the sole proprietorship, why is it, do you think, that we see any number of businesses being conducted as sole proprietorships?
To use a phrase that Dave McGee, another attorney in the office, likes to use, it's cheap, quick, and easy. It's cheap because you don't have to do anything. Maybe register a fictitious name, which is a couple $100 tops with the state. It's quick. You wake up one day, decide to go into business for yourself, and you don't have to do anything else. And it's easy because, like I just said, with those first two steps, that's all you have to do, and you're a sole proprietorship. So if you're a contractor, you register with the Attorney General's office. If you're an attorney, you just throw up a shingle, essentially. But as a sole proprietorship, there's not a lot to do to get you to the point of where you can be conducting business. That's why I think they're so prevalent.
Well, it's interesting you mentioned attorneys and home contractors, both of whom have certain licensure requirements. And I think it's important to point out to our viewers that even if you are a sole proprietorship and an unincorporated business, so to speak, there are licensure requirements that may still apply depending on what kind of business you're undertaking.
Great point.
Now, along those lines, I've often worked with startups. Perhaps you could call these types of clients enthusiasts, where they want to, test the waters, so to speak. And I don't think there's anything necessarily wrong with conducting business in an unincorporated form if you are, quote unquote, testing the waters, so to speak.
I agree with you. I think the one caveat I would put on is make sure you have the proper insurances in place.
That's exactly where I was going. So it sounds like it's a good idea, even if you are unincorporated, to get the appropriate type of insurance to afford some level of protection.
Absolutely.
But the insurance will not protect a party operating business from debts that are incurred during the course of the business. So that's the key caveat there. Insurance is appropriate, insurance is necessary, but it doesn't cover every eventuality. So you do have to take a look at your capital needs, the needs of doing business for the first 6 months or a year or 2 years, and project out what those costs will be. If you're able to get goods or services on credit, that's good, but it means that you will build up accounts with various vendors, and that's what I was talking about earlier in terms of the debts owed to vendors, various service providers. Insurance will not apply to that, and that's where you could get in a little too deep, and you could find yourself on the receiving end of a lawsuit from one or more vendors against you personally, which would jeopardize your assets, money in the bank, vehicles, even equity in your home.
Sounds like it could be a disaster waiting to happen, so to speak. Now, I don't know about you guys, but even if an entity is formed, I still recommend appropriate insurance as a first line of paying, not necessarily vendors, but judgment creditors, for instance.
Well, the right set of circumstances. You want liability coverage. You want workers' compensation coverage if you have employees. Various other coverages that are customary in the commercial context, yes.
Certainly. Let's shift gears a little bit. One of the drawbacks, if you will, of a sole proprietorship or an unincorporated association is there is no what we call continuity of life, meaning the person, he or she that operates that business as a sole proprietorship is the business, so to speak. So what happens, Jim, in that circumstance if that person passes away?
Oftentimes, unfortunately, the business dies with that person. So, you know, they're so key to the efforts of running the business, managing it, and performing potentially the services if it's a service-oriented business, that when that person passes, their business is going to pass with them without really a lot of planning or potential to help carry on, or to use your word, to have that continuation of business. That's why if you structure it with an entity, you can build in that succession planning as part of that entity and the documents related to it.
Now, Jim, I know you do some estate administration work. Gary, you do not typically, but you know, in my own practice, I've seen where the owner, so to speak, of the sole proprietorship passes away, and the executor essentially has to have an auction or a fire sale of the assets because the business has gone away. There is no one to carry on the business, so to speak, and no use for the assets. Mm-hmm. Certainly, I don't think that's a best-case scenario under any circumstance.
No, I mean, I've seen that fire sale concept as well, and that's usually it's a last resort, essentially. If you can avoid that, that's usually beneficial to the beneficiaries of that estate so that they can maximize the value of that business that was probably operated for 20, 30, or 40 years. It was a lifetime for that individual, that sole proprietor that was operating it.
I want to cover one more topic before we move on to the team, if you will, that we recommend be in place if and when a business owner decides to form an entity, and that is a tax-related item. And it goes back to, Gary, what you had talked about earlier, and Jim as well, about the simplicity, if you will, of a sole proprietorship. And that is simply the fact that there is only one tax return for the sole proprietorship, and it's the tax return of the owner, the 1040 of the individual. He or she simply reports the business items on his or her personal return. Another perhaps recommendation for a sole proprietorship, the simplicity inherent there too, but still probably a good idea to get an accountant on board because you are dealing with more than just your garden variety individual tax items.
Mm-hmm. Absolutely. The other nice thing with using an entity, particularly the LLC, as you know, you can tax shop and how it's taxed. It can be taxed as a corporation where it's not a pass-through entity. It can be taxed as an S corporation where it is a pass-through entity. It can be taxed as a partnership. It even could be taxed as a disregarded entity, which is fairly similar to a sole proprietorship if there's one member of that LLC. So forming an entity, good for liability, and also allows you the tax shop, which may or may not be good. And that's, to your point, that's a great conversation to have with an accountant. Is there tax dollars that can be saved by choosing that entity?
Well, it sounds like, particularly with regard to limited liability companies, as you were just talking about, there's a lot of flexibility. And when I hear flexibility, I immediately think of a need for planning.
Yes.
And when I think of planning, at least in my practice, I think of a team of professionals. Gary, perhaps you could tell us a little bit about that team that I'm referring to.
Yeah, the team would consist of both an attorney and an accountant, which are very important. I hear a lot of advertising for formation of corporations or limited liabilities by services, primarily in Delaware, but advertising which indicate that formation of the entities are quick and cheap. But that service only goes so far. It doesn't include any guidance or any planning at all, and the guidance and planning are really critical to the ongoing operation of an entity as it moves forward. And that's what we provide in consultation with a client's accountant. It's invaluable, and it really is necessary as the business moves forward.
And I would add one more person to your list beyond the attorney and the accountant, and that is an insurance agent as well, particularly one that deals with commercial lines as opposed to homeowners and auto, personal lines, so to speak. Would you not agree with that?
Yes, yes.
Well, with that, we're coming up on the commercial break, so we will see you right after this word from our sponsor. Thank you.
How would you build the perfect bank? Would you put it close to your home or your work? Would you make it a high-tech wonderland with web banking and 24-hour access? Or a hometown bank with tellers who know your name? If you could build your perfect bank, it might look a lot like National Penn Bank. Convenient branch and ATM locations, innovative technologies for 24-hour access, attentive personal service, and free checking with no minimum balance or monthly account fees. It's all right here at National Penn Bank.
There are many reasons people join AAA and renew their membership year after year. In addition to the peace of mind of emergency roadside service, AAA membership includes expert travel planning, exclusive discounts, and more. AAA members also get exclusive Show Your Card and Save discounts at participating retail merchants and can save money on theme park tickets, luggage, and travel accessories at the East Penn Travel Store. Join today and start taking advantage of all AAA East Penn has to offer. And visit us on the web at www.aaa.com.
Welcome back to Legal Talk, the talk show brought to you by the law firm of O'Donnell, Weiss & Mattei. We have an office at 41 High Street in Pottstown and another at 347 Bridge Street in Phoenixville. We can be reached at 610-323-2800 or online at www.owmlaw.com. My name is Joseph Koury, and with me are my colleagues Gary Stein and Jim Kovaleski. We spent the first half of the program talking about the pros and cons of conducting business as a sole proprietorship, as well as a general discussion about conducting business in some form of limited liability entity. During this half of the program, we're going to focus a little bit more on the different types of limited liability entities that one could conduct business through. And I think it's safe to start with a traditional type of limited liability entity, and that is the corporation. Many of our viewers will be familiar with the corporation in general, but perhaps not the different levels of management and authority that a corporation has, whereas other types of entities may not. Gary, could you talk a little bit to that concept?
Yes, but before I do that, I wanted to add that a general partnership is not a limited liability entity. So if 2 or 3 individuals join together to conduct business, those individuals are not protected from the debts of the partnership. It's a really important point. Same risks that come from being a sole proprietorship are present with a general partnership.
I would even say, take that one step further, Gary, and say you're at more risk and potentially to general partnership because the actions of your general partners could impact you and you could be bound by those actions. So it's a viable option, but you have to be aware of those
Yes,
risks.
that's right. You may not even know about the action your partner has taken, but you are legally bound by them. So it is somewhat risky. So now we go into the two most common forms of limited liability entities. The first one is a corporation. That's well known. And a corporation basically has three categories of governance, shall we say. One is a shareholder, the people that contribute money for the initial capital to the business. That's not a debt, that's an investment in the company. There's no expectation of getting it back. If you loan money to a corporation, that's a loan. That's not capital, that's not stock. So we have shareholders holding stock. That's the first plane. The shareholders then meet and elect directors. The directors really govern the corporation. They make the decisions, they have the authority to make all the decisions for the company and set the course, shall we say. The directors, in turn, elect officers, hire and fire employees, and it's the officers that then implement the day-to-day decisions and affairs of the corporation. So that, in a nutshell, is how a corporation works.
Now, in my experience with corporations, many times they're small, what we call closely held, just a few people that need to fulfill all three of those roles, because all three are required for a traditional corporation. And I find, in my experience with the closely held business, that it can become unwieldy because of the need for those three levels, those three constituencies, so to speak. Have you had that experience, Gary?
Yes, it's true. Now, it's important to adhere to corporate formalities for limited liability. And if you do that, you generally won't have a problem with your creditors. But we use a term called piercing the corporate veil, which is where a creditor of the corporation can attempt to pierce the limited liability protection and then sue the shareholders, officers, or directors for some kind of misconduct in the operation of the corporation. But that's a good reason why the corporation needs good corporate counsel to help the directors and the officers maintain the corporate formalities and do things properly.
Now, one exception to that general concept, and frankly, I think it's an underused exception, not enough people avail themselves of the opportunity, is the so-called statutory close corporation. Jim, have you ever had experience with one of those entities?
Yes, I have. I think you're right in the sense that they are underused. I mean, I thinking back, I probably dealt with maybe one or two out of the 100 or so corporations that I've dealt with. So they're out there, and you can use them. You have to meet the statutory requirements for them, and they're pretty strict, and you got to make sure you fall into those lines. But they can be of assistance in situations like that.
For our viewers, essentially the three constituencies are collapsed into one, meaning the shareholders, the owners of the business, if you will, having authority that would typically be at the board of directors level. Again, in the statutory close corporation context, assuming all other requirements are met.
Mm-hmm. You have to file your documents that way as well. You can't just decide one day to you wake up and I'm going to be a statutory close. It's an easy check the box, but you got to make sure that when you're filing your articles of incorporation that box is checked.
Again, to me, it sounds like a opportunity for planning, if you will.
Yes.
So that's essentially corporations in a nutshell. I think now it's appropriate to move on to limited liability companies, which frequently are what clients approach us having in mind when they're thinking of forming an entity. I think there's a lot of advertising out there, Gary, to your point earlier about LLCs, being the preferred vehicle to conduct business within, and I think for good reason.
Yes, I agree. In fact, I recommend them to most of the small businesses that I work with these days. Basically, a limited liability company is a hybrid of both a corporation and a partnership. The part of the corporation that is present in an LLC is the limited liability protection, which is very significant. The part of the partnership that is present is for tax purposes and also for flexibility and governance purposes. You don't have the three levels of governance: shareholder, director, and officer, and then coming with that is the requirement each year to hold annual meetings of both the shareholders and the directors, and then to prepare minutes following those meetings. The context of governance for a limited liability company is compressed. Instead of shareholders, you have members. That's what the people that invest money in the LLC are called. And then when you file the certificate of organization, you have to make an election. The question is, will you be managed by the members or will you be managed by a manager? You have to make that election on the certificate. And if it's managed by the members, then the members jointly agree on all major decisions. If it's managed by a, quote, manager, then the manager will make the decisions based upon the authority granted to the manager by the members. There's no requirement to hold annual meetings. There's no requirement to have minutes prepared. It's a much more flexible entity, especially within the context of a small business.
Sounds like a lot less paperwork, which is, I think, something that most small business owners would say is a good thing.
Correct.
Now, back to your concept about a manager. Does the manager actually have to be a member, meaning an owner of the LLC?
Not necessarily. The operating agreements that I prepared do not require that. And actually, let me talk about operating agreements. With a corporation, we have articles of incorporation, and then we have bylaws. Bylaws consist of the rules for governing the corporation. And then where you have more than one shareholder, it's advisable to have a shareholders agreement between those shareholders. So those are the three documents we commonly have with respect to a corporation. In the context of a limited liability company, we have only one document that deals with the bylaws and the shareholder agreement. It's called an operating agreement. It sets forth the rules for governing the LLC. It also contains things like buy-sell provisions and other provisions that would commonly be in a partnership agreement or a shareholder agreement.
Very good. Again, given the flexibility, I think there's also some complexity that could be inherent to a limited liability company.
It's true. You have the same issues in terms of planning, successor planning, and the like, and that's why there is the need at every step of the way for good counsel, good lawyer, good accountant, etc.
Very good. Well, we've been speaking tonight about conducting business in an unincorporated form, meaning a sole proprietorship, and the pros and cons associated with that. We've talked a little bit about forming an entity to conduct business, the traditional corporation versus the limited liability company. We talked briefly about partnerships, general partnerships. We really didn't talk about limited partnerships. Jim, maybe in just a few seconds you could explain the utility of a limited partnership, particularly in Pennsylvania.
Sure. Pennsylvania is unique because of the capital stock and franchise tax. That's a specific tax that is charged by or collected by the state, and it applies to corporations and LLCs and certain other types of entities. One way that you see that limited partnerships used is ownership of real estate, and the reason that is because of that capital stock and franchise tax. Partnerships, limited partnerships, are not subject to it, so that's why Pennsylvania is unique. You'll see a lot more limited partnerships here than you will in most any other states. But the concept of a limited partnership is basically it's an entity that it's a partnership, but it provides limited liability protection because it's a limited partnership. What you have there is you have usually one general partner. You can have more, but you have one general partner. That general partner is on the hook for potentially for any liability exposure of the entity. So vendors like Gary mentioned earlier, or other judgment liens or things like that. In Pennsylvania, at least in our practice, you'll see that oftentimes that general partner is a limited liability company or a corporation, most often a limited liability company, to contain that liability exposure to that one entity, so you don't have an individual exposed. The other part of the limited partnership, so you have the general partner, is you have limited partners. Limited partners, think of them as purely investors, because that's what they're doing. They're investing money in exchange for a limited partnership role. The limited part of their partnership interest is that they don't have a say in what the partnership actually does. All of the rights as to make decision making and things like that are held by the general partner. So if you have a general partner entity, they're going to be the one that's going to be, that entity will be responsible for entering into contracts, buying, selling real estate, things like that. Those limited partners are pretty much there for the ride. They've invested money and hope to and expect to get a return at some point of that money, maybe when the real estate sells and the partnership goes away. But that's in a very brief nutshell what a limited partnership is.
Thanks, Jim.
Sure.
I think we can all agree we've given the viewers a lot to think about. Certainly, we are prepared to assist the viewers with their planning needs and tailor our advice to their specific situation. But again, going back to Gary's recitation of the team, we are proud to serve alongside your accountant and insurance agent in meeting your business planning needs. On behalf of the law firm of O'Donnell, Weiss & Mattei, thank you for joining us tonight for Legal View, or Legal Talk rather. We'll see you next time.